Gary is the owner of Meridian Land Surveying LLC, and he's also chaired both the NSPS committee and the ALTA committee on the ALTA, ASM, now NSPS standards since 1995. Gary's the past president of both ACSM and ISPLS, and from 1999 to 2006 taught boundary law, legal descriptions, property surveying, and land systems for Purdue University in Indianapolis. He is in his 13th year on the Indiana State Board of Registration and Professional Surveyors, and is frequently called on as an expert witness in cases involving boundaries, easements, and land surveying practice. Gary regularly presents programs across the country on surveying topics and writes the columns for American Survey Magazine and contributes to the NSPS News and Views. Without further ado, Mr. Gary, we thank you for being here today. And I don't think anybody on contract law, I think you're the expert, when I think in the surveying world, at least, that everybody looks up to. So we appreciate you being here.
Oh, it's my pleasure, Trent, and I'm happy to have the opportunity to present to you guys and hopefully provide you some helpful information. So we're going to talk specifically about contracts today, and I always want to throw this up there, and especially in a program like this. I'm not an attorney, so a lot of times people will say, what about this this term or this clause in a contract? I'm like, the contracts are really quite state specific. And, as an example, in Indiana, our client owns our product. The contract says otherwise. So, of course, our contract says otherwise, but it's very state specific. This program is actually based on this publication, which again you can find on nsps.us.com under their e-store, and under the books section, it's called Staking Out Your Future. It is a joint publication, or it's actually a publication of Victor O'Shinner, which is now just called Victor. But we have ACSM and now NSPS has had a relationship with Schinnerer. I will have trouble calling them Victor, but with Victor for decades, literally. And Kurt Sumner and I have both gone to their offices numerous times to present both to their staff on surveying issues and also to do like webinars for their insureds on survey issues. So I think they're a great company, but this is a really good publication, and you can get it for $10. So I would highly recommend you seeking that out and getting a copy of that.
It's on sale right now for $8.
On sale for $8. There you go. That's even better. I just looked at that yesterday. Are you serious? It actually says that?
Yeah. Well, maybe that's because I'm logged in as a member. So it says you save $2.
That could be. Yeah, maybe members get $2 off. Yeah.
That's what it is.
So. All right. So contracts, a written contract. It is a risk management tool, and there are three really important items. The first one is the scope, right? We need to have a clear, concise, well understood, and precise scope. This, because we're going to be held to this, right? So we need to make sure it says what we want and that it's covering the things to be done. Secondly, the compensation. Right, and we want to have clauses in there that say they're going to pay promptly, and they don't get to withhold money unless you're in some situation like that. And if they decide to put the project on hold till next year, no, we're not going to start up under the same rates or that sort of thing. There's a whole lot of stuff we can put in there regarding compensation. And then the third thing is schedule. I always kind of resisted. If I could get away with it, I resisted putting the delivery date on my contract. I usually said something like, as agreed upon, because I don't want there to be construed as a warranty that I am going to deliver by this date, because sometimes things come up, and those may or may not be under my control. If they are, acts of God, then that's actually a clause in the contract anyway. But I want to try and avoid that. Sometimes you have clients who you just know they absolutely have to have this thing delivered by a certain date, in which case I would put it in there. But I generally acknowledge when they want it delivered, and they trust that I'm going to do it. But I try to avoid actually putting it even in there. So here's an interesting question for you. Are there more claims that result from written contracts, or are there more claims that result from oral contracts? Or are they about the same? Right? Well, the answer to that is that there are about 60% of claims occur when there is a written contract, and about 40% of the claims occur when there is an oral contract. This is a couple years old here, but I don't know that you can draw any dramatic conclusion from that, because I suspect that that's probably about the percentage of work that is done under a written contract and under a verbal contract. I know that there used to be an attorney at Schinnerer named Joe Jones. He's a really good guy. Kurt knows him. And he used to tell us, or he told me one time, he said, when I have an insured call and say, oh, I have a claim, he said, the first thing I always asked them was, what did your contract say? And he said, I was so often disappointed because they actually didn't have a contract, right? And what I would clarify and say, they didn't have a written contract. 100% of the time, I think under the law, they would say you have a contract. It's just that if it's in writing, it's understood that there is a written agreement as to what you're going to do. If it's verbal, that's when you're going to have some issues of, well, but he told me, no, that's not what I said, type of thing. So that's one of the values of a written contract, is that there's a definitive meeting of the minds in writing. Now, one of the disadvantages of a written contract, probably the only disadvantage I can think of actually, is that at least in some states, the statute of limitations for breach of contract is less. It's shorter for a verbal contract than it is for a written contract. But I don't think by any means does that outweigh the advantages you get from a written contract, where you can put all kinds of clauses in there like, hey, if we have a disagreement, are we litigating this in Las Vegas, or are we litigating this in Indianapolis? Well, if I'm in Indianapolis, guess what? No, we're going to litigate this in Indianapolis. So there's so many advantages to having a written contract, which is what we're going to talk about here this afternoon. So why is it a risk management tool? Well, we can outline our expectations very clearly. We can outline the obligations. I'm waiting. The client has to provide me certain information, and we have certain rights. I have the right to walk away from the contract, right? As a surveyor, I want the clause in my contract that says I can fire you. Every one of us has worked for clients who were like, man, I wish I had never got into this situation. And yet, unless your contract says that, you may not be able to just walk away. The risks and rewards, and we're going to talk a little bit about that as we go along, that we address that, and they are allocated. This is a very important thing, right? Sometimes clients want you to just do a little bit of a job and pay you a little bit of money, but it's actually very high risk. And so we have to sort through those sorts of things. Do I have professional liability and general liability insurance to support what it is that I'm doing? We can cover those sorts of things. And change orders. One of the things, I don't remember if I actually have this slide in here, but there are a tremendous number of claims that occur coming from additional services. tremendous number of claims from additional services, even on written contracts. And the reason I think is because, you know, when we get into our contract at the front end, you know, we give a lot of thought. What's the scope? You know, we get it down in writing and everybody reviews everything and they sign it. And then you're in the middle of it and the client calls and says, hey, by the way, can you do this? And you're like, oh yeah, I can do that. And you don't go through the same careful process of thinking about the scope and thinking about all the extra things when there are additional services. And then what happens is, you know, then something goes wrong and they have a claim and you're like, well, we had a really great scope of work on the original, but we didn't do such a good job on the additional services. So that's a really important point. That's just a fact. There are a lot of claims that come from additional services. So it's kind of a gut check for us to think about that. And again, the written contract, it's in writing, right? So, and you know, the advantage there is that courts will hold you to what it says, right? They'll hold you to this. And you might say, well, you know, I don't want to be held to it. Well, if you wrote the contract, then, you know, you would hope so. So let's talk about some things that you want to watch for, because we all know that sometimes you have a contract, maybe you have your own company contract and you're going to go to work for somebody and they're like, oh no, we'll send you our contract, right? Well, be very cautious on that stuff, because I can assure you that their contract has one thing in mind: shifting liability off of them onto you. That is, I mean, that used to bother me, but it doesn't anymore, because that's why you hire an attorney, right? You have an attorney to protect you. And attorneys will try to get you to do things and say things and certify to things that you shouldn't, because they're just doing their job, right? And it used to bother me. It doesn't anymore, because I'm like, yeah, it's just part of the game here. But things that you want to be careful of in a contract that's put in front of you: express guarantees or warranties. You know, you're gonna guarantee that you are going to, I think I have a slide on this later, that you are going to do certain things, or you're gonna warrant that this is gonna be to the highest and, you know, the most strict standards or whatever. You have to understand that if you look at your professional liability policy, one of the first exceptions is express guarantees and warranties. They will not cover those. You can warrant facts, and I've had people say to me, "Oh, my insurance company won't let me use the word certify." Like, to me, my response is, you need a new insurance company, because the word certify isn't the problem. I can certify that my name is Gary Kent. I don't think there's any problem there, right? That's a fact. But when you're warranting services, you know, I'm gonna certify that I gave you the best survey that you could possibly get. That's going to be a problem. And you have to look at the clauses in these contracts very carefully, because they will disguise them. You know, one little word they'll stick in there that looks perfectly fine, but it's actually not. It's not a problem. Trent, I see some people popping in. Are you catching them as they come?
Yeah, it's Steve was just making a point that if you have a contract with the Department of Justice or state attorney's office, you'll have to abide by their contract. So, yeah.
Yeah, and actually, I'm glad you said that, Steve, because we have clients who are, you know, national, international corporations, and the fact is, if they say it's going to say this, you know, and it's federal and state government too, you're not going to say no, I don't think so, because they'll just go to the next person. So there are situations where, for example, I said our contract says that the work product belongs to us. Well, if my clients who I want to do work for, and there's some major corporation, and they say, no, I don't think so, we're going to own it, then you make a business decision, which is exactly, you know, what we have to do, which is, well, they're going to own this stuff. Do I want to go ahead and do this? Or they have some onerous requirement in there. what's the risk reward and do I want to go? So yeah, there are occasions where you're just going to have to be stuck with what it is. Other things, indemnity or hold harmless clauses, and you'll see this in contracts too. Again, if you're stuck, if it's a very sophisticated major client, they're probably going to tell you to shove off if you don't want that clause. So you have to make a decision. But if it's just somebody and they stick that in front of you, what are they doing? They're trying to shift liability. They will put things in there that say, I literally saw a contract one time that said, if we are on site and something goes wrong, it's our fault, right? It didn't have anything to do even with our services. And I read that and I'm like, oh, no, seriously? And I read it again. I sent it to our attorneys and they're like, yeah, that's what it says. So you probably don't want to sign that, right? So, but I think it's important to point out that you may think, oh, they don't do that kind of thing. Oh, yes, they do that kind of thing because they are, and in a case like that, if I raise the issue, they're probably going to say, okay, that's fine, because they know it's unreasonable, right? It's above and beyond what my legal obligation is even, right? I always get nutty when I see a contract that says I'm responsible for my own negligence. A contract doesn't have to say that. That's common law in the United States, and it has been forever. Just things like this. You just want to be careful that they're not trying to hold you to something that's outside your scope of work, and that's and that is above and beyond what your obligation is, which is to meet the normal standard of care. So this is actually what is it? Your legal duty does not exceed what? The indemnification of losses directly caused by your negligence, your contractual agreement, or the extent of your liability coverage. Under common law, it's the losses caused by your negligence, but you can write a contract that actually makes you more liable than what common law would hold you to. So you have to be careful with that kind of thing. Your legal duty does not exceed the indemnification of losses directly by your negligence. and this is the important point. Your E&O, your professional liability policy, covers you for negligence. It doesn't cover you for being stupid. Right? It doesn't cover you if you sign a contract that says, yeah, I'll take responsibility for anything that goes wrong. They're not going to cover you for that. You took that upon yourself. So your contract, you don't want to extend your liability to people other than whom you would have otherwise been liable. And if you take on risks that above and beyond what your negligence would be, then, and sometimes this happens, it's like, I can do that, but you're going to have to pay me more money to do that, which is perhaps a fair trade-off. Right? Highest standard of care, I alluded to this one a minute ago. You see this frequently in client contracts where it will say that I am obligated to perform my work to the highest standard of care. I will tell you, if you get sued, you are going to lose hands down. And the reason you're going to lose hands down is you cannot prove. The highest standard of care is not a written standard, and you cannot prove that you did it. So why do they put that in a contract? For that very reason. Because if they don't like what you did, they'll sue you and say you didn't meet the highest standard of care, which you signed the contract said you would. They will win. I routinely, when I would see those kinds of contracts, cross that out, and I would say something like, we will conduct our work pursuant to the normal standard of care and Indiana Administrative Code 865 IAC 1-12, which is our survey standards. So, and I've never had anybody complain about that. Now, again, if it's a major client, they may put that in there, and I may have trouble crossing that out, but I have to make a business decision in that case. So what's our problem here? Yeah, they want us to perform to the highest professional standards. Well, what's the problem? It's vague. It's immeasurable. They win if they sue me under that. Right? The common law standard is well documented in the law. The duty to exercise the degree of learning and skill ordinarily possessed by a reputable surveyor practicing in the same or similar locality and under circumstances. That is my legal obligation. And I want to make sure that my contract doesn't extend me beyond there. So we may need to educate them, right? A measurable standard is to their benefit, unless their whole thing is, trying to hose me, or you're going to pay me more money, right? Pay me more money because I've got a higher level of responsibility. I have more liability. We can look at stuff that you would want. So this is in your own contract. You have a contract. These are things that I want to have in there, right? Who's responsible for what? Right? I'm going, or it might be in their contract too. Obviously, I want to be responsible only for the stuff that that is directly related to my services. I don't want to be responsible for what the contractor should be doing in construction, for example. That's not my thing. And a very, very important point I alluded to a minute ago is that your professional liability insurance policy is not going to cover stuff like that. One of the things you get with your professional liability, or what people call it today, it used to be called errors and omissions, and people still use that term, but the proper term is professional liability. But one of the things you get with that is your agent will be more than happy to come to your office and do training, review contracts, all kinds of things, because they don't want you to have a claim any more than you want to have a claim. Worker safety, right? My obligation is to provide a safe work environment for my employees, but I don't typically have control over the job site, right? So I want to make sure that the contract is not trying to foist off responsibility for the job site safety onto me. And by the way, what that means is that if your employees go on a job site that's not safe, you need to have a protocol for that. I remember years ago, we had a situation where we had a crew went downtown Indianapolis, and we had a client, and they said, hey, they were doing this project where they were going to connect between two buildings. They were building a new building, and the new building was going to have a connection to the basement of the building next door. And they had excavated out, and they wanted us to go and get some shots on the building next door. So I sent the crew down, and the crew called and said, hey, this isn't shored up. They've just like dug the dirt away, and they want me to go down and get this shot. And he said, I'm not really very comfortable. And I said, well, tell them that when they get this shored up, or they put a box or something in there, then we'll come back. So that's what he told him. We left. This is a true story. The next day, on the front page of the Indianapolis Star was a photograph of a survey crew member for another company, because when we told them we weren't going to do it, they hired somebody else that day who got there. The guy is buried up to his belt in dirt, and I can still remember he's standing there smoking a cigarette, right? And on the front page of the paper. And I'll guarantee somebody paid a few $1,000 fine for that. But I was always so glad it didn't say, you know, an employee of the Snyder Corporation. You know, so we have protocols at our company. It's like if you go on site and you know they want to go on scaffolding, you have some kind of basic understanding of what scaffolding should look like, or they want you to go in an excavation and you understand we do some training, and you know there's some basic things so that you can look at it and say, you know what, I don't think so, because you know we want them to raise those issues with us so that we're not putting them in an unsafe situation. And I think we may be talking about safety here in a couple of weeks. Agency, right? Unless I'm hired directly by the contractor, I would like the contract to say that I am acting as an agent of the owner. Why? Because then the owner is in between me and a lawsuit. They're going to have to sue the owner to get to me, basically, right? And that provides some cushion, and it also provides a better opportunity to mitigate things. What else? I mentioned this one earlier. Who's going to control the documents? You know, who owns the stuff that we produce? Right? Well, one of the terms we like to talk about is, you know, a product. Well, what's the product of a land title survey? Well, it's the plat. Well, not really, right? The plat is an instrument of service, right? We surveyors don't generally produce products. We provide professional services, right? So someone is hiring me to perform the service of producing a land title survey. An instrument of that service is the plat. It's not really a product, right? And if we can clarify that, that might help mitigate situations where somebody's like, well, that plat belongs to me because that's a product of what you did. No, it's not a product of what I did. It's an instrument of the services that I provided. And in that context, I own it. But again, state laws vary, varies widely on this, so you would want to look at that. But that last check down there, copyright and ownership are two different issues. I can go to a bookstore and buy a poster of a Picasso painting. I own that poster. Can I reproduce it and go out and sell it on the street corner? No. Why? It's mine. I should be able to do that. No, because it's copyrighted, right? So copyright and ownership are two different things that we need to be cognizant of that even in our contracts.
Hey, Gary.
Limitation. Yes.
Gary, Jimmy had a comment. He wanted to know how successful your argument has been. I believe Maine law sides with the client in that the documents produced are the property of the client.
Yeah. So in Indiana, and again, this is very specific state to state, but you might ask your attorney or check with your your attorney probably is who you need to talk to. But Indiana state law is very definitive on that issue. Indiana state law says the client owns the work product, right? Well, I can have two arguments there. One is I could say that plat is not a work product, it's an instrument of service. But Indiana law also says client owns the work product unless the contract says otherwise. So our contract says, thank you very much, but we are retaining ownership of our work product. So a couple things buried in there. One of them is the difference between a work product and an instrument of service. But the other is to see what the state law says in that regard. So we're fine with it here because it's in our contract that we will own that information. Now, again, we have clients who say, no, we're going to own it. And, you know, if it's a big client that we do a lot of work for, we're just going to have to live with that. Limitation of liability. I think this is a really, really good one. I believe our contract says that our limitation of liability is the value of the contract or some dollar amount. And I don't remember what ours is. Let's just say, for sake of argument, it's $50,000. So this is the problem we have as surveyors. You know, we may end up doing these little piddly little job. We stake a house, right, for whatever, $700, $500, $300. We stake a house, and we make a mistake, and a house gets halfway built, and it turns out that we screwed up, and now they have to tear the house down and move it over. Okay, that's fine. I make mistakes, but I can't have a business model that says I get paid $300 when I routinely have $200,000 in liability, right? And so you can put a limitation of liability in your contract. Now, again, you have to, talk with your attorney about what the law says. But there was a case in North Carolina a few years ago where a surveyor had a contract, and I don't remember what the limitation of liability was, but for the sake of argument, let's just say it was $50,000 or the value of the contract. And it was a construction staking project, and they made a major error that costs the client about $500,000. I'm trying to recall the exact numbers. And this has not been that long ago. This has probably been maybe 10 years ago. So they made a claim against the surveyor, and the surveyor is like, well, here's, the contract was for 15,000, here's your 15,000 back. And the client's like, no. It cost us 500,000. So they sued, and the trial court said, yeah, that's not a fair balance here. $500,000 error, 15,000. No, you have to pay them $500,000. The surveyor, or probably the surveyor's insurance company, appealed it to the appellate court or the Supreme Court, I don't remember which, in North Carolina. And that court said, you know what, you're right. That's not a fair distribution of risk. You shouldn't have signed the contract. So they upheld the limitation of liability. Now, when is this appropriate, right? Well, it's appropriate when you're not getting paid much money, or even if you're getting paid a significant amount of money, but your risk is extremely high, right? There's a disparity between the risk that you're taking and your fee. Now, some people will say, we have clients, we put that in front of them, and they cross it out. Well, then we make a business decision. What's the risk and reward? I talked with Joe Jones at Schinnerer a number of years ago about this. And he said, if the courts in your state don't uphold it, then they don't uphold it. He said, I would go ahead and put it in my contract, because if they don't uphold it, you're no worse than you would have been. And if they do uphold it, then good for you. Now, some surveyors seem to think, well, that's kind of cheating, right? Because if I make a big error and I only have to pay them $5,000, my response is, it's in the contract, right? If they don't like it, they could say, well, how about not the value of the contract, but how about 100,000 or whatever? It could be negotiated, but most of the time people just sign it. And I don't feel bad about that. It's put in writing. If they question it, we can talk about it. But if they don't question it, it's right there in front of them. They had the right to question it. And I just can't have a business model where I am exposed to very high liability for relatively low fees.
And I think on that note, most construction staking type stuff, at least with bigger firms, you're going to sign their contract. So unfortunately, I mean, we have the same thing. It's, limited liability is the contract amount, but when you're signing the construction contractor's contract, then that's a little hard, but
yeah. No, you're absolutely correct, Trent. And I mentioned that earlier, and I'm glad you reiterated, because that's where you make business decisions, right? I mean, They don't want a limit, or they want the limit higher. Okay, well, what's the risk reward? And, maybe we'll be extra careful or whatever. So we go
Yeah.
into it with our eyes open. That's the important part there.
Yep, exactly.
You also want your contract to have something about dispute resolution. Are you gonna, do you go like straight to court if there's a problem? No, we don't want to go straight to court. I want mediation, arbitration, something else. And in some states, they have a whole variety of things, peer review panels or that sort of thing. There's a whole list of them that I don't have in here. So here's a question for you. Professional liability managers prefer contracts that call for what in the event of a dispute, arbitration, mediation, or litigation? They prefer contracts that call for mediation, right? Because it is less expensive, it is less time consuming. I mean, that's what happens when you get into a lawsuit. How long do these things take, right? Years they take. And it's also less adversarial, right? It's two parties come together trying to find an agreement. So the interesting thing that we all know, especially if you get involved in construction staking on a very large project, everybody knows that things go wrong, right? I mean, that's just life, right? There's going to be a problem with the plans, or everybody just knows something's going to go wrong. And so having this written into the contract is just an acknowledgement that says, we know things may go wrong, and here's what we're going to do if they do, right? It's kind of like being an adult about it. Let's talk about it ahead of time and get it into the contract. What do we like about mediation? It's voluntary. Now if it's written in a contract, you're going to have to go into it, and you would hope that it's in good faith, although it's not always. There is a facilitator or a mediator. I've actually had mediation training. I took training to be a mediator about 4 or 5 years ago. It was 40 hours, 8 to 5, Wednesday through Sunday. It was me and 39 attorneys in there. It was one of the best classes I ever took, by the way. But mediators should be trained. Because mediation is I really liked the class because it helped me understand that my role, if I was a surveyor and trying to mediate a boundary dispute, my tendency is going to be try to point them to the correct solution, right? Where does that boundary line actually belong? But that's not actually the role of a mediator, right? The mediator's role is try and get them to agree to something that they're both happy with. So usually mediators, certainly if it's court ordered, it will probably be an attorney, but it could be, if two parties agree to a mediator, the court might waive the requirement. They're not on the list. Yeah, but you both want them. Okay, well, whatever you guys want, you can do that. So that's a positive thing. Versus arbitration, which is where we both go into it and say, we're going to basically present our cases to someone who is going to decide the answer. And there's a couple problems with that. It's kind of like people who say, well, we'll take it to the judge. They'll know what to do. Judges don't know what to do. And you may be in arbitration with somebody who doesn't understand the issues. And the other thing is that you have to be careful with arbitration is that some clauses on arbitration will allow other things to be drug into the dispute, which may be above and beyond what your responsibilities are, might be a problem from your professional liability standpoint. So I had that in there. It protects you and the client, right? So let's talk about land title surveys here for a second. Many of us do them. Here's the problem on a land title survey, the contract. Who are we, who's requiring the survey? Well, the lender's requiring it, but for specific purposes, which means that the title company needs it, and yet I don't typically have a contract with either the lender or the title company. I have a contract with the buyer or seller, which is a weird situation when the people who are kind of dictating what needs to go on the survey isn't my client. Right? So it's kind of an odd situation there. And the odd situation is what motivation does, whether, especially if the client, on land title surveys, it depends on the state. In some states, the seller pays for the survey, and in some states, the buyer pays for the survey. In some states, it's purely a function of what the contract says. In Indiana, in my state, it's the seller. Well, the disadvantage of that is what motivation does the seller have to pay for a really expensive, great survey? They don't have any motivation for that, right? They just want enough to get across the finish line. And so we end up with this weird problem where the lender and the title company need a good survey, even though the lender really doesn't care. And yet nobody wants to pay for it. So it's a very odd situation. What we will do on a land title survey is we'll be very specific, and we're talking about 2016 here, even though the new standards go into effect here in about 6 weeks. We specify that we're going to conduct our survey pursuant to those standards. We also say it will also be pursuant to 865 IAC 1-12, which is our Indiana survey standards. We also include whatever table A items there are. And then we may need to put some qualifiers in there. If somebody says table A item 11, one of the things we have to understand is that when people check off the underground utility option on table A, what do they think they're going to get? They think they are going to get complete, accurate, reliable information on the underground utilities. And yet we all know that it's going to be incomplete, it's going to be unreliable, and it's not going to be accurate information unless they excavate the whole site. So one of the things I will do is there's a note that follows table A item 11. I will clip that note out and put it in my scope of work. Right? And I also put it on the face of the survey when it's done. What are we doing? We're trying to control their expectations. I specify that it's going to be the certification in section 7. I specify the parties, right? And I'm saying this because I hear from people say, well, what do you do when they call back and they say, well, I want you to add the law firm and add this and add these parties. Like my contract at the front end says, I'm going to certify to 3 people. If I have the commitment and I know who those 3 people are, well, it's Chase Bank, and it's First American Title, and it's the ABC Corporation. I list them on my contract, and I say, we will certify to these parties. Additional parties may be certified to for an additional fee. Now, if it's a regular client and they want a law firm, I'm probably just going to go ahead and do it. But it does put me in the driver's seat. If I don't know who the parties are, my contract says I'm going to certify to the title company, the lender, and the client / owner or buyer. And that way I'm still in the driver's seat. We say that we're going to provide the certification in section 7, not some other certification. If they want another certification, I have a clause in there that says we will provide the lender's certification. However, the wording will be negotiated to my satisfaction, and it will be provided on company letterhead cross-reference to the survey. It's not going to be on the face of the survey. The standards don't allow that. It says in there that they're going to provide the title work. It says in there that we are going to provide one set of revisions based on the consolidated comments of all of the interested parties. So I'm not going to do a set of revisions based on the lender's comments, and then 2 days later, a set of revisions based on the buyer's attorney's comments. They need to all get together, put them all in one document, send them to me, and we'll do that. And any additional revisions, assuming that they're not my fault, those will be T&M. And I'm getting close to being done here, I think. This shows, and I don't know if I don't know if this is in the way, but let me move this over just in case. This is a form somebody gave me a while back. This was several versions old, because you can see it says ALTA, ACSM. But this is one a company took Table A, and they did this. And what they would do is they would do the research to figure out, well, there's 37 monuments. That's going to be this amount of money. And they want vertical relief. It's this amount of money. And then they would fill that in. And they would send it to the client and say, you need to pick off which Table A items you want. And every item had a fee associated, other than the ones that they would automatically do. Like they said, well, we'll do the addresses and we'll do the land area. But that way, the client sees right in front of their face, no, we can do that item. There's how much it's going to cost. And I asked them, and they said, oh yeah, you'd be surprised how few things get requested under that situation. Someone actually sent me an email one time that was a response from a client. They had sent the client an email with Table A, and they said, tell us which Table A items you want. And the client had written back and said, by the way, with respect to Table A, we want all the items that don't cost anything. Now, in my book, that's none of them. Right? I think every Table A item ought to cost something. You want addresses? That's $50, whatever. Don't tell me the attorneys do stuff for free, because they don't. Certification, what's a problem? This is what happens to us right at the last minute, probably less than it used to be, but the lender comes in sliding in the day before closing. Oh, we need this this certification. And you can't change anything. They may not even want it on the face of the survey anymore, which we couldn't do anyway, but they're like, oh no, you have to sign this, and it's got all kinds of problems, right? Keep in mind, they know that there's wording in there that we should not be certifying to. They know that. I have been told by attorneys they know that, right? All they're trying to do is get us to take on liability that doesn't belong to us. And so you have to take exception to that kind of thing. All right, we have an obligation. I'm going to rewrite the certificate because I can't make express guarantees or warranties. I don't have any insurance for that. I can't violate my registration act, which they will sometimes get you to want you to say things. It's like, that's not even the practice of surveying. That's a legal opinion, as an example. Right? Here's another item, CAD files, right? Sometimes clients, oh, we need you to give us a CAD file. Okay, that's fine. I want to address that in my contract, and it's in my contract. Right? That's the problem. Well, what are the issues here? The issues are this. I want this to say that the hard copy, signed, sealed copy controls over the CAD file, right? Number one, the legal document is the one that's signed and sealed, not what's in the computer. Number two, that information, again, is just a part of the instrument service that we did. Number three, I'm not representing as to the use of it for any other purposes, because you know what happens. You do the land title survey. They want the land title survey in CAD, and they're going to send it to the architect who's going to do design on it. Right? Well, I didn't do a design survey, an engineering design survey. I did a land title survey, and it wasn't for that purpose. Right? And transferring the information does not transfer my license. I could still, depending on state law, again, I might still own it. So the important point here is in yellow, and that is you need to have this all covered, because once you send that out of your office, boy, it is out of your control. So you want to make sure that that you got yourself covered. No, I'm not going to send you subsequent revisions unless you ask for them. You know, one of the things that can happen is maybe it's a situation where, in fact, the client owns the work product, and then somebody wants you to send a CAD file to somebody else. Right? Well, I might not even have the legal authority to do that because under the contract, I don't own it. You know, it's stuff that we need to think about. Hazardous site, you're going to be on a hazardous site and they want you to provide those services. You know, things we need to think about. They need to provide protection to us, safety issues. Usually it's not a problem because usually I'm being hired by some environmental firm. They've got the insurance for this. Um, and they need to be responsible. They need to train us. They need to tell us what the hazards are and that sort of thing. But it's stuff that you want to think about if you're getting involved in that. Not to mention the you know, the risk involved. I know that I think at our company, depending on the you know, the type of hazard A through D, we increase our rate 25%, 50%, 75%, 100%, depending on what the risk or what the hazard level is. Third-party claims are a really distinct possibility when you're on a hazardous site. Now, you're probably not going to be held culpable if all you were doing was setting some stakes, but they will drag you in, right? We know that's what attorneys do, is they name every possible person who could be held responsible, and it's going to cost you money to get out of it. So what you want to try and do is get a release and indemnification from the client for any claims that are resulting from what someone else did. I'm more than happy to be responsible for a bad stake, but I'm not responsible if the contractor broke through a dike and some hazardous material got into a creek and I set a stake out there. That's not my responsibility. Additional insured, I think I'm almost done here. I know I said that a minute ago. A client wants to be named as an additional insured on your professional liability policy. This happens all the time on general liability, right? They're like, well, you know, your auto, if somebody crashes or if some problem happens and we need to be an additional insured. That's not how it works on a professional liability policy. You can't you can't name someone as an additional insured on your professional liability policy. It doesn't work that way because they pay on behalf of me if I was negligent or substandard. They don't pay to the insured. Right? And so you can't name someone. So what happens is if somebody requests that, I'm like, I got to be a little careful because they don't know what they're talking about. And I may need to have my broker talk with them. Again, I mentioned high risk projects. You know, the risk is far in excess of the compensation I'm going to receive. Think of that. Can I have a limitation of liability? Can we get indemnification? You know, because you get these claims, right? They're meritless with respect to my services, and yet I get drug into it. So we just need to think about that sort of thing too. So that's what I've got. I want to put this back up here again, Staking Out Your Future. It is a really, really good publication. I would highly recommend it if you're an NSPS member, and if you are, you know, if you're a NALS member, you are an NSPS member, you can get it for $8. And it is a really, really good publication. So I would highly recommend that. This is my contact information. I tried to retire from Schneider at the end of last year, which extended it to the end of January. And then they asked me to stay on part-time to help them with some things, kind of internal consulting and also with some safety things. So I created Meridian Land Consulting to do some consulting and expert witness work that I do. But I am still part-time with Schneider. That's actually my Schneider phone number up there. I meant to put my other number too, but you can reach me either way, and I'm always more than happy to take questions. So if anybody has any now, I don't know where our timing is, Trent, but
we're
that's
good.
what I've got.
We're good on there. Anybody can unmute themselves and ask the questions away. And then Sean just put in the chat, are there any questions on the FS and the PS relating to these business and contract topics?
Oh, that's a good question.
Yeah.
I actually have not been involved. I don't believe there probably would be on the FS. There might be on the PS, but I have not been involved in that exam for quite some time. So I actually don't know if there's any business contract related things on that exam or not.
Yeah. Hey,
that'd be something to look at in the exam specifications.
Yeah.
Yeah, that's a good point, Rob. And they also give example questions and stuff too. And actually, to be honest, even if I was involved with exam writing, I couldn't answer that question anyway.
Right. Exactly. Exactly. I don't know. Is Jocelyn, are you still on here? I don't know if Jocelyn's on here. Nope. Looks like she jumped off. I was going to say she might have been the most recent to kind of take the PS exam. So.
Yeah.
But
hey, Gary, this is Rob McMillan. I just want to say congratulations on your attempt at retirement. I thought I was doing it wrong, but apparently you're doing worse at retiring than I am.
Yeah, I'm telling you, Rob. And to be honest, I didn't realize this literally until a couple weeks ago. It's been almost a year for me. And I'm like, I am just as busy as I was before I retired. And I'm like, what is going on here? I can't figure it out. Well, I realized that the last several years when I was at Schneider, all I was doing was working on seminar stuff and expert witness and consulting. And they let me take all that work with me. So when I left, I still had all the same work that I was doing before. And quite honestly, it wasn't until a couple of weeks ago, I'm like, oh, that's what happened. So, I would prefer not to be as busy, but I love it. That's why I do it. So, I'll just keep doing it until I decide I want to slow it down.
Right. Exactly. Jimmy was the one that didn't have a microphone. So, Gary, I know this is very state specific, but do you mind sharing any standards, terms, and conditions as it relates to a survey firm? I plan on reviewing mine after this PowerPoint and was just curious about how yours is structured. So
yeah, if I would be glad to share mine, which is based on Schneider's, and they probably wouldn't want me to share it if it was a competitor out here, but you're in Nevada. I would be more than happy to send you my contract and you can see what's in there. And you are correct. I always tell people, be very cautious because it is very state specific. But if you want to send me an email, I'd be happy to send you what I use.
Yeah, that's from Jimmy. And I think he was saying he's in Maine. So.
Okay. Yeah. Well, either way.
Right. Yeah. It's outside of Indiana. So there you go. Jimmy,
Yeah.
You got his email on the screen there if you want to send him a separate email.
Yeah, please do, Jimmy.
There you go. And then Mike says there's some specific contract questions on the state specific for Alaska.
Okay.
Yeah.
Interesting. Yeah.
There probably should be on the California specific, since that is an item in state law.
That's I was thinking that, Rob, that California is the only state I'm aware of that requires a written contract for surveying services. So it would be appropriate for them to have some questions on that.
Nevada recently changed theirs through administrative code. So NAC, the board laws require a written contract now as well.
Oh, good for you guys. I think that's entirely appropriate.
Yep. Must be in writing. So Gary, Jesse says in the chat, Gary, can you please expand on the requirements of resolving a boundary for an ALTA versus just showing the legally described bounds and then monumenting said property?
Yeah, so section 3D, I think, 3 dog in ALTA NSPS standards basically says that this is a boundary survey, and it says that the survey must be conducted pursuant to the appropriate boundary law principles that are governed by the evidence and the facts that you have. So a land title survey is in fact a boundary survey. And so I know there have been people, at least in the past, who had the impression that our obligation on a land title survey was simply to use a term that I probably should clarify, but it's just like slap the math on the ground, right? Pre-calculate it and just slap that math on the ground. That's what our obligation is. That is incorrect. Our obligation is to perform an appropriate or to perform a boundary survey using the boundary law doctrines that are governed by the evidence and the facts that we have. So what I want to say, the choices that you gave, the first one is correct. We need to do a boundary survey. We need to look at the evidence and decide where are the boundaries, where do they belong based on the evidence. You know, if we have an original survey, our obligation is to retrace the footsteps. And I'm doing a whole seminar on that issue, by the way, what I call the art of retracement. Just taking the deed and the math, and sometimes I've talked with Jeff Lucas about that. At one point, he would use the term, deed staker, and people would just stake the deed. And I said to him one time, I said, well, Jeff, that's actually what we're supposed to do. I think the term that the pejorative term that you're looking for is slap the math on the ground, because we're supposed to stake the deed. But we're supposed to stake the deed based on the best evidence. And if the best evidence is an original survey, then we stake it based on, retracing the footsteps of the original survey. The description in the deed is simply an effort to memorialize what was actually done on the ground. Our job is to reproduce what was done on the ground. So this idea of just, pre-calculate everything and go out and set points, that's not what we're talking about. That's not a proper boundary survey, and that is not what we should be doing on a land title survey. So I hope that answers that question. If not, follow up, please.
Yeah, before you had frozen earlier, I was asking if you're attending the NOWS CLSA conference and that kind of stuff. If you're presenting, yeah.
I'm not presenting it now CLSA
The whole state,
directly,
yeah.
but
Yes,
I know that there's that multi-state program of 7 or 8 states. I will be presenting for that. Yeah.
Perfect. Is your research, is that one you just talked about going to be on there?
Actually, I think it is. I can, let me look at my phone while we're talking. I can look at my phone because I think it is.
Rob is CLSA state president this 2021. So.
Okay. Right. Good for you, Rob. They want me to present on the new standards, and then they want me to do a second program. And I think I suggested to her my program that I call the Art of Retracement. I think I suggested that one to
okay, cool.
her.
I think that is the one the committee said, oh, that sounds good. That sounds like one.
Oh, yeah.
Good.
Oh, great. I'm glad to hear that, Rob. It's fun presenting. It makes people think, and it is all new. I mean, it's a completely different program from what anybody is doing. And at the end of the program, I throw out some very provocative thoughts that some people will probably get upset about, but it's rooted in good stuff. And I'm glad that you're going to hopefully choose that one.
Yeah, good. You got to choose that one, Rob.
I think we already have.
Perfect.
Okay, excellent. Excellent.
Cat's out of the bag. We're good. George, he's up. He's from Reno and said, "Thanks, Gary, for sharing your expertise. I've always believed that there are many good surveyors, however, there are not very many good businessmen."
You know, that is so true, George.
Yeah.
Why do people start a survey business? Because they love surveying. They don't start it because they want to do employee reviews and make accounts receivable calls, right?
Yep.
I love calling
Exactly
clients
right.
and telling them to pay me, right? And so, and that is not unique to surveyors. I mean, anybody in a technical profession has this very same issues, but you're absolutely correct, and that's one reason I like sharing programs like this to hopefully help people, because it helps all of us, right? If somebody's a poor businessman, they're probably not charging enough. They don't understand their responsibilities, and it's hard to compete with people like that. I would rather compete with somebody who knows what they're doing than someone, and I don't mean that pejoratively, but no. I'd rather compete with someone who's a good business person than someone who's not.
And that was the whole premise behind January being all about business. So just kind of,
yeah.
Say,
Gary, I would say you're not the only one that's unsuccessful at retirement. Yeah. I tried 10 years ago. I'm back working, but it's on a limited basis. I enjoy who I work with, both staff and clients. I've got a couple I'd like to fire, but I'm doing what I enjoy doing, and it's really fun.
Yeah, I'm glad to hear that, George. And you know, something that is unique, and I don't share this a lot, but I know doctors who do not like being doctors, and I definitively know engineers who do not like being an engineer. I know attorneys who hate attorneys. It is very, very rare to find a surveyor who says, you know, I really don't like surveying. Surveyors almost universally love the profession, and that's why we do this stuff. And I'm glad you said that, because it's a very, very interesting thing that I tell people who are, you know, their kid or somebody's, you know, thinking about surveying, and I said, I'll tell you one thing, you're probably never going to regret becoming a surveyor. Right? You may not like who you work for, you may not like your work situation specifically, but generally people love the profession.
Don't we generally all like the ability to try and solve a problem? And isn't that what our real goal is? Right. Is to solve problems, and we sure got lots of them. And it seems to me that we solved all the easy ones about 30 years ago.
Yeah, Gary, that's
that's very true. I actually said to somebody, you know, be careful with anybody. I think especially of politicians. Anybody who tells you there's a simple solution to something, guess what? There aren't any simple solutions left, right?
Yeah, that's why we don't sleep at night. But you know, in my role, it's, you know, I retired and I needed a break, but you know, I had some health problems, and you know, kind of contemplated, you know, with too much time on my hand, worrying about how long I had to live, and said, you know, I like this mentoring, you know, there's something I can give back. So I'm working again, but that's really part-time. I'm out of my cabin 100 miles away from the grid, and I'm mentoring some great young LSs, and there's not enough of it. And I like doing presentations. I'll follow in the footsteps of Mr. Parrish, because he's, you know, gives and gives and gives. And you know, it's something we all have to do in our careers. And I guess at our sunset portion of our careers is really a good time to do it, to share some of those gray hairs. And I appreciate you, Gary. You've been excellent over my whole career of all the effort that you put in to help people out. So thanks a lot.
Exactly.
Thank you. I appreciate that. And yeah, you know, who was it? Teddy Roosevelt talked about giving back to your profession, I think. And that's why I keep doing this. You know, number one, I love it, but number two, I just feel like as long as people give me good ratings and think that I'm being helpful, I'm going to keep doing it because I think it's important.
Somebody took the time to share all of this knowledge and information that we have with us, that I think it's absolutely our duty to continue to share it and pass it along.
Absolutely, George.
Well stated, George.
Exactly. Anybody got more questions before we
Just a comment from Rob here. I believe we're going to have Michael Schroeder and Steve Parrish also as presenters at the Magnificent Seven conference.
Excellent. Excellent.
I might note one thing though to this group while we're here.
Yep.
We're kind of at a crossroads. I might be sticking my neck out a little bit among all of us that are administering a CFEDS program. And we're kind of at a crossroads as to where we're going to go with CFEDS, because everything's still based on the 2006, 2007 platform. And it has affected the elimination of flash, has affected a number of the things we have that we have not prepared for over the last 4 years. And I won't go into the detail, but yeah, I will commit myself to do some presentation, but at this very point, I'm not sure it's going to be a CFEDS presentation. That's yet to be determined in the next, I don't know how many weeks. I do know that a contract between NSPS and our provider for our CFEDS site, that contract is due to be renegotiated on April 1. And we're in conversation between NSPS, the BLM, and our contract holder. And I'm just a little old training coordinator in the middle of it all. So I can't promise what's going to come out come March.
Oh, then.
Hey, Steve, this is Rob McMillan. Maybe a survey program that has quite a robust enrollment could do something to help update the program to more current software applications. You know, if Flash is one of the things that's being used in that, maybe that's something that Purdue or the Ohio State or
yeah, the problem we have, it's a little more difficult than that, Rob, in that the BLM owns all of the content, and one person owns the site and all of the let's say the technical aspects of that site, the code and everything else. And we know that there's been a few interested parties over recent years, would like to step in and, take over CFEDS. But the problem that the BLM has with it is that CFEDS was designed to teach private surveyors the ways and wherefore of Department of Interior, BIA, BLM surveying procedures. And we're all aware that there's a rather significant difference at times doing surveys against federal land and then all other lands. And I see Gary's nodding his head, fully aware of that, right, Gary?
Yes.
And so if CFEDS was to say go privatized, I know the BLM would look at it and say, well, what kinds of things would the private people want to attach to CFEDS when it's been designed as a BLM related manual of surveying instructions, BIA Indian land surveys? And, could that be diluted or, changed or something? Because we still have a lot of people, I run into them all the time, that do not like what the BLM manual says. So, and I know, Mike, you're more than familiar with that up there in Alaska. You've been with the BLM long enough to understand all that too. So it's not just as easy, Rob, to turn around and say, well, let's put it in the hands, because I know that we could put it in the hands of some private people and have this thing up and running I think pretty soon, but I'm not an IT person either.
Well, you know, you need, somebody needs a 12-year-old grandchild to help with the technical stuff.
Right.
Yeah.
Steve,
Yeah.
I think your points are well taken. I had a almost over an hour long chat with Dominica here a couple weeks ago and just catching up and talking about my presentation up at the Big Seven conference, make sure that was all good, which it is. And yeah, that was a decision in the founders when you know, Ron Schuler and Dennis Moulin, you know, who's going to own and who's going to, you know, own the content and own the code. And there's never a right decision, you know, but it
Yep.
Well, I'm not advocating, you know, taking BLM out of the loop at all. My thoughts were to possibly have a university program that has these bright young minds that have learned Python programming or whatever the hell they're learning these days that I don't know how to do, to update those under contract with the BLM, or perhaps provide updated content for BLM's blessing through NSPS, through a contract with NSPS. You know, something that would support the students in the university program and update the content to what BLM needs. Not just the format of the content, not change the content of the program.
Right. Yeah, well, it is being rather vigorously discussed at this point. I can't speak to how much progress we're making. We've known of the problem for over 4 years. I jumped in as the training coordinator and accepted the position in May of 2017. And I've been trying to work towards, you know, where are we going to go? What do we need to do to change things so that, the other problem is that, you know, you can't do anything in CFEDS on Apple. We're needing to make CFEDS be online, immediately accessible on every platform, on your cell phone, on your tablet, whatever, you know, is needed. The only thing that will continue, I'm sure, to control is the final examination once you've entered the program, because it's like the NCEES model. You do have to still protect the question bank and things of that nature. So, you know, that's the only part. Right now, I've got 6 more, possibly 8 more people taking the CFEDS exam on the 5th of February. And everybody's still been able to, since last March or so with COVID, they've all still been able to find a proctor for themselves, and that has to be an in-person thing. And nobody backed off from that yet. They're still working it. So
Cool.
Still a go, but
Okay.
I'm betwixt and between, because I've been here since the very beginning of the advanced cadastral survey courses way back in the 70s. Right on through the CFEDS now. And I just, not that I own it or have an ownership, but I sure love being a part of it.
Absolutely.
So we'll keep working it out as best we can.
Talking about this cadastral survey courses, Steve, I think I have the cassette tape program for those somewhere. And I would guess that probably maybe a third of our attendees today don't know what exactly a cassette tape is.
Not to mention an 8-track.
Oh, now we're talking, Gary.
They're right on my shelf next to my Betamax.
Exactly.
3/4 inch wide tape.
Awesome. Couple of things. So next week is Mitch Duray going to present on the challenges. So kind of the opposite, the challenges of running a business. The following week, Gary Kent's going to be back presenting. He talked about his safety program. So Gary was gracious enough to present for a safety topic as well at the end of the month. So couple of good ones. And then anybody who follows Geoholics, he started a Thursday kind of once a month virtual happy hour type of situation. Probably a a little more like what we did at the conference, just kind of open-ended roundtable discussion type stuff. So you can check out their social media for that stuff as well. But you can check the website out. I've got everybody booked all the way through March 1st. Actually, just tonight while we were on the meeting, I got March 8th booked. So we are good for a little while, but always looking for more.
Trent,
So,
Trent,
yes, sir.
thank you so much for putting all this together.
No problem. Thank
This is an absolutely wonderful, positive addition to the profession.
you. Yes, sir.
Gary, thank you for sharing your time and expertise with us.
Absolutely.
And Steve, I can't even begin to talk about the things I've learned from working with you.
Thank you, George. And I see
Yeah.
a number of thank yous, and
Absolutely.
I would just say, everyone, you're
Yep.
very welcome. It's my pleasure. I look forward to seeing you in a couple of weeks.
Awesome. Thank you, guys.